You see, this is not entirely true, is it? When in this Public Order Act, oh no, sorry, this is no, this is true. Yeah, this is the Public Order Act repeals. So this is 1985 or 1986 even. 1985 is when they formed the CPS, Crown Prosecution Service. So this is, check the wording out on this. Let's get some clarification. The offences under the following enactments are abolished, right? It says, Section 1 of the Tumultuous Petitioning Act, 1661. The presentation of a petition to the monarch or parliament accompanied by excessive number of persons. But that's actually not the case. That's not true. Because the law actually says that no one can put their hand. No more than 20 persons can put their hand to a petition that is to be presented to the king. You can't sign it unless you've got it checked up through a court. Right? So this is published on Parliament website, legislation.gov.uk, and this is wrong. This is false information, and we've got Rashid Sunak, or whatever he's called. He can't call himself Rishi Sunak in a meeting if it's been disrupted, because if he disrupts it, because he has to give his name and address to a police officer, the correct name and address. So the fact is, this is wrong. The law actually says that no one can put their hand to it, no one can sign it. Right? If you check it. So this is legislation that's published on a government website that is misinformation. Yet they're saying that they want a Ministry of Truth, or the BBC want to have a station that is correcting information. You know? Well, here's some information to correct for a start. And what I want to know is, in the other... Hold on. This is, look, Tumultuous Petitioning Act 1661. So this is the first amendment to that act, which was 1967. And this is in the act where they've conjured up assisting offenders, which later, when that Tumultuous Act is pulled, the Crown Prosecution Service is set up, and they conjure up assisting offenders from that. Which is when someone is acting in a case or pursuing criminal matters or a criminal case because they are obviously a witness, and no one can obstruct them because they're pursuing crime. In Section 1, the words, this is in the Tumultuous Act, at the court to quarter sessions. But this was 1967. This suggests that the original wording of the Tumultuous Petitioning Act didn't have the quarter sessions in it. It was courts. That would mean that if we're looking for any evidence of petitions existing or surviving or cases, we don't want to be looking in the quarter sessions, that other than the fact that unless the quarter sessions were just any court like another court, it got changed to quarter sessions from courts. Why would you do that? And the ironic thing is, the quarter sessions didn't really continue much long after this. I think it was You can check this, but I noted it down in my notes that when I looked, it said 1971 or something around that time. You'll have to check on it. But that means that if it was 1971, for example, if these quarter sessions were still being run up to 1971, it's 67, 68, 69, 70, 71. So you'd only get 5 years of quarter sessions. But when did the assizes run? But you're still leaving the words in it, the assizes or the King's Bench. Now, the thing with the assizes, the assizes did go up to 1971. The assizes did go up to 1971. So at the time of 67, 68, 69, 70, 71, the assizes were still running. So there will be some assizes, possibly, from 67 to 71 that might have evidence of petitions in them being presented or checked. But what I want to know is, why didn't they remove the King's Bench from the Tumultuous Act? Seeing though that the King's Bench, as it was known in the 1688 Bill of Rights, was a different King's Bench. It was a King's Bench court that had a plea side and a crown side, and it ceased in around 1701, shortly after the Bill of Rights. And the current Queen's Bench, or King's Bench we've got now, the High Court, is a different court to what originally King's Bench was, because that ended. So it's almost like, what I'm getting the hint of now is that the royals have never really liked the right to petition. They've never liked the petitioning rights. And ever since Oliver Cromwell, whatever, and the restoration of the crown, they've gradually been stripping it back away, sneaking it back away, but it's too obvious for them to take away the 1688 Bill of Rights because it's the more well-known. So instead, they chipped away at it. I think that they've been trying to hide evidence because, Parliament burning down in the 1800s, 1830s, when the police force appeared, you've got these common informers. People are bringing their own criminal cases until the police is formed and they start doing it themselves. We lose all of the petition cases from the House of Commons, which set case precedent over all England. It's higher than all of the other courts, remember, Parliament. So it's going to set case precedent for all those petitions, what they're about, what you can petition about. Some legendary cases probably from the Civil War. People who did certain things, most likely, maybe even those Painted Chamber ones as well. Although Brodie Waddell he's only got some quarter sessions one, but I don't know what Brodie Waddell is doing looking around in the quarter sessions because it didn't say quarter sessions of the Tumultuous Act until the last 5 years. So if you're looking for them, you're looking for them through all the courts, not in the quarter sessions. They were mixed in with all the courts. So where are they? I mean, is it like looking for a needle in a haystack? Brodie Waddell says he's only got and he hasn't transcribed all of them. He's transcribed a selection of them. He's got Privy Council, House of Lords, and some quarter sessions ones from a few courts. So where are all the other courts? And you would have thought it would have said the quarter sessions all the way through. And then they'd have changed it to all courts. It seems odd. Why did they do that in the last 5 years? And then, why did they pull the whole thing when the Crown Prosecution Service is set up? What we're going to use for petitioning when they've got election petition rules. Don't worry, we've got assisting offenders for us. Well, what all my assisting offenders? Well, that's your problem, Well, you better go see the Attorney General, the head solicitor of England, or the chief crown prosecutor, director of public prosecutions. No, whoa, this is my investigation, not the Attorney General's. I'm running this, I'm investigating this, I'm investigating the Attorney General. I don't need his permission, This is it. This is the problem. Where I want to know what is happening in these proceedings where over 20 people sign petitions. I want to know, what is it, civil? Is it criminal? Is there a prosecutor there? Are they saying, all right, we're doing this, we're doing that? Okay, then that's fair enough. Go ahead. On you go. What's happening? Are they giving deemed and express consent to the petition activities? Like, it's Gail Bradbrook. Hello, how are you doing? Okay, here's a petition. Put the hands of 150,000 women to it. Oh well, let's have a look. Where's the larger part of the grand jury in this case? What you want to be doing? Putting a few windows through, climbing up a bridge, parading through the streets, airports, cutting fences, getting on, sitting on planes, putting a window through Department of Transport. Oh, let's have a look. Let's see what the grand jury think. What do you think to this? Oh, they like it. I think it's rather exciting. Okay, then on you go. This is it. Is that it? This is it. Or, well, this is. We need to know. We need to know what's going on. Is it anything like these peculiar proceedings of the Election Petition Rules and Corrupt and Illegal Practices Prevention Act? And what about the prosecutions? Well, you're getting prosecuted for turning up with petitions that hadn't been checked beforehand and given the go-ahead. But were those prosecutions also encompassing facts and circumstances around the activities as well? Now, if they'd been given the go-ahead from the courts, then surely they'd been given the go-ahead for what activities they were going to do. And if it was under 20 people, probably likely been considered to, you don't need to get it checked off. You can just do it. Probably didn't think they were going to get up to too much trouble, 20 persons. So, that deemed an express consent basis that's in the statutory instrument, which, according to the seeking a resolution from either Houses of Parliament using an enactment, are the prosecutions subject to an annulment? It would seem so in the statutory instruments of the Town and Country Planning Act. All these offences, fines for defacement, are given deemed an express consent. Are they subject to an annulment? If you're using the enactment of Class F, do you want to how do you want to say this? What language you use is subject to an annulment of the instrument, doesn't apply if you're using an enactment, or is giving deemed express consent through the enactment. We can take it whichever way you want. It's the same thing. It seems to me that you're seeking a resolution through that enactment from either Houses of Parliament or the King. So, order, instrument, you use the instrument to make an order, right? So if the instrument's annulled, then you're making no order with it. That's the point, right? And if you're not subject to the instrument because you're exempt from half the sections in it or all of them, then there is no instrument. Same thing. It seems to me that's the principle in effect here. Something that Max Hill does not seem to understand. Although, I am not going... he clearly doesn't either want to read all of the law. I don't want to read all of the law. He doesn't want to read all of the law. He wants to read the law that he wants to read and use, not the law that he doesn't want us to use and read. That's the problem. So, that's where I am with it at the moment. We need Brodie Waddle's got these petitions to transcribe. Well, I've read through of them. People are talking about privileges and being granted them, and people ignoring it. Even in those, in some of the samples that I pulled out to look at, mainly people who are doing work for members of Parliament or peers, and apparently granting them immunities or whatever. So it was something. It was a hot topic back then. I can't see how we won't have full records through the 1920s legal cases, 1930s legal cases, 1940s legal cases, 1950s legal cases, and 1960s legal cases, and 1970s legal cases. There's got to be a comprehensive, detailed record, although not in magistrates' courts, because we don't write anything down. I've been in, everyone knows what happens in magistrates' courts, pure corruption. So unless it's maybe the assizes have got these honourable recorders that you become an honourable recorder, a court recorder. Well, where are these records if they're so honourable? Where are they all? We need to know.